Then, third session, Professor Zhang Baosheng is professor of law now in the University Renmin of China. Before, he was, for instance, former vice president of the Chinese University of Political Science and Law, and he published a lot of books and several papers in very important journals and publishers in questions referred to the evidence. And I pass the floor to Professor Baosheng.
I'm very pleased to be here to attend this very important conference. And I want to thank the university and Professor Rudy inviting me give a presentation. My presentation will try to rethink the conventional Chinese evidence series and the system, and predict the future development, especially transformation from the objectivity to relevancy. The principle of evidential adjudication has been basically established after almost 40 years of reforms in China. However, the operation of such a principle still encounters both theoretical and institutional barriers, specifically as concepts of fact and existence were mixed up. Objectivity instead of relevancy has been regarded as the basic principle of existence. Moreover, some judicial notions are still dominant in China, such as seeking truth from fact, zero tolerance to wrongful convictions or acquittals. These conventional ideas distort Chinese evidence system. So we argued there are difference between empirical fact and objective evidence. Fact is a logical starting point of evidence law. In terms of features of fact, there is a debate between objective fact and legal fact. Chinese criminal judicial philosophy has always equated fact of a case with the objective fact, asserting that every case has an objective fact accessible to human cognition. This judicial philosophy was derived from former Soviet Union scholars. The objective fact theory confuses the fact with the existence. Existence refers to the objective world, independent from human consciousness, whereas fact is a real existence perceptible by human mind and senses. Fact being a concept of epistemology is truthful, empirical, and describable. The truthfulness of fact can be illustrated from two aspects. Firstly, a fact takes place at a certain time-space dimension. Secondly, fact is something that has occurred. Fact is not subject to any changes. Once a fact occurs, whether you like it or not, it is unchangeable in history. The difference between objective existence and empirical fact is the very one between the knowable and the known. The knowledge about objective existence can be acquired by human thinking. By contrast, the knowledge about the fact requires people's perceptions and experience. In this regard, Wittgenstein said, the world is a totality of facts. The difference between the fact and existence can be illustrated by the ratio of explicit number of drug abusers to the implicit one. In 2014, about 3 million people were registered as drug abusers in China, which was an explicit number and an empirical fact. According to a ratio of 1 to 5, about 15 million people in China were estimated to be implicit drug abusers in the same year. However, we have no knowledge about this implicit group, including their identities, what type of drugs, what time and place they took. So that was a knowledge, that was a knowable objective existence, not an empirical fact. The fact is expressible. It can be illustrated by knowledge, presentation, and acquisition, upon which 3 arguments are made. Firstly, what is known can always be expressed. Secondly, the listener is supposed to know a fact described by the speaker. Thirdly, a proposition or statement could be true or false. As a result, there appears a scenario where a single fact has 2 opposite stories. As there is no standard for testing whether evidence is objective or not, it is neither possible to examine the objectivity of evidence, nor does the theory have any epistemic significance. Since evidence can be true or false, it is impossible to answer which kind of evidence, true or false, is objective. Regarding the relationship between the fact and evidence, only when epistemic subject is involved could such a relationship gain epistemic significance. 3 models are as below. The first model is a subject's direct interaction with the fact in the present tense. He or she can actively know fact by repeated observation and practice in daily life. The second model refers to the relationship between witness and fact in the present tense. 2. Because seeing is a theory-laden undertaking, the accuracy of the observation or a statement could be affected by witness perception, memory, sincerity, and narrative ability. The third model involves the fact finders ascertaining past fact only by evidential reasoning. In the trial, the fact finder has no personal knowledge about what happened in the past, so evidence serves as the only bridge that connects the object and the subject, or a mirror reflecting past facts to the present. The mirror of evidence doctrine reveals the limits of evidential reasoning. That is, the truth is like flaws in the mirror. Professor Shu Weiguang held that if the subjective knowledge is consistent with the object world by over 50%, this knowledge can be regarded as truth. This notion of truth is well demonstrated by the preponderance of evidence. However, the conventional Chinese judicial notion of thinking truth from fact misapplies the relationship between the subject and the object in the present tense, described by the second model. For that, in the past tense, implied by the third model, thereby failing to regard a conclusion inferred from evidence as the truth in mirror of evidence. In the trial, as the fact finder has no personal knowledge about past events, the judicial notion of thinking the truth from fact is not applicable. Instead, what the target of a fact finder is evidence rather than the fact. So it should be thinking the truth from evidence. The modern evidence system is established on the foundation of relevancy, which serves as a rational basis for judicial confidence. Evidence is the information relevant to the fact of consequence used to prove whether a proposition of fact is probable. Just as Professor Allen said, the central issue of relevance is whether evidential fact relates the fact finder's prior knowledge and experience in order to permit the fact finder to rationally process and understand the evidence. This is based on the trial's logic and general experience, which demean that the logic form of fact-finding is mainly inductive. In the chain of evidential reasoning, as Professor Twining demonstrated, generalizations are necessary but dangerous. They are necessary because each step of inference must be rely on the G1, G2, G3, G4. They are also dangerous simply because society's stock of knowledge upon which generalizations usually consists of impressions, speculations, and prejudice, which determines different levels of certainty. So, every step in the chain of empirical inference could probably be the source of uncertainty. For example, the trial court of Nianbing case had accepted the prosecution's arguments. The defendant saw a customer walked towards his door, finally turned to victim's store instead. He thus became resentful about victim. The judge inferred defendant's motive from the evidence, then concluded his intention to kill her result from believing the victim took away his business opportunity. However, people may suspect the inference based on the generalization above. Is it consistent with the common knowledge? But the judge failed to raise doubt about its regionality. So wrongful convictions are more likely if induction is based on unreliable generalization. So about the probability of the truth and standards of proof, Professor Anderson, along with others, illustrates that there are 5 reasons why conclusions based on evidence are probabilistic in nature. That is, the incomplete, inconclusive, ambiguous, dissonant, and imperfect credibility of evidence. These reasons account for error risks of evidential reasoning. The probability of truth is presented in the standard of proof. In the civil case, the fact finder must find by a preponderance of the evidence that the plaintiff's claims are true. In criminal cases, the issue of guilty must be proved beyond reasonable doubt. This is also the requirement by Article 53 of Chinese criminal procedure law. The probability of the proof standards challenges to the judicial notion of zero tolerance to wrongful convictions and acquittals, which can also be expressed as neither convicting an innocent person nor acquitting a guilty one. In response to this idea, Justice Shen Deyong of Supreme People's Court said a wrongful acquittal is better than a wrongful conviction. The above debate indicates that influenced by objective evidence theory, there are problems with the Chinese accountability system for misjudged cases. In Chinese judicial reform, a lifelong accountability system for judges has been put in place, which upholds the slogan of correcting every wrong whenever discovered, and the judge should be permanently held accountable for misjudged cases. It requires 100% accuracy for fact-finding. According to China Justice Index in 2015, the average scores for the Index on Occupation Guarantee for Legal Professionals was 67.6 with 100 in total. When asked about views on the protection mechanism for judges' performance of statutory duties, only 19.2% of judges expressed their satisfaction with it. In judicial practice, a judge, Wang Guirong, at the District Court of Henan Province, was sentenced to 1 year and 9 months in 2011 for guilty of dereliction of duty, which put a risk of judge's profession. So we predict a trend of transformation from objectivity to relevancy. In recent years, the theory that upholds objectivity as a basic principle of evidence has received more criticism, where relevancy has played an increasingly important role in legislations, judicial practice, and academic research. In legislations, both the 1979 and 1996 criminal procedure law defend evidence as any fact that can prove the truth of a case, and neither of the two laws contained a single word of relevancy. This phenomena gradually changed subsequently. In 2012, the description of relevance was found in Article 48 of Criminal Procedure Law. That is, any material that can prove facts of a case is regarded evidence. Also, there are 4 articles in judicial interpretations of SPC on criminal procedure law that request deliberation of relevance for different types of evidence. That is Article 69, 40, 84, 92, and 93. But relevance rules are placed at a lower position between the 4th and 8th section along the hierarchy level of evidence rules. The concept of relevance has been increasingly applied in judgments since 1996. After searching database of Chinese adjudication documents, we found that of the 389 criminal judgments made before 1996, no contained the word of relevance. Of the about 3.4 million criminal judgments made from 1996 to 2017, about 60 8,000 judgments included the word relevance, accounting about just 2% of the whole. In addition, some Chinese textbooks of evidence have discarded the objective evidence theory and stressed that relevancy is the basic principle of evidence. Nevertheless, the transformation from objectivity to relevancy in evidence theories or system has not concluded in China. In evidence law scholarship, conventional theories that argue for evidence objectivity are still influential. In legislations, relevancy has yet to be established as a fundamental principle for the evidence system. To achieve the success of the transition from objectivity to relevancy, the key is to build an evidence system and evidence theory with relevancy as a logical thread. In 2011, as one of the commitments to this goal, research on the provisions of procedural evidence was approved as a project by National Social Science Foundation of China, with Justice Shen Deyong as the chief expert. Members of the project include 15 judges and 15 faculties in my university, COPR. Professor Allen is only one foreign advisor for this project. There are two major methods for the project, namely rethinking Chinese evidence theories, and on that basis, recompiling the present 415 provisions on evidence. The primary mission is to logically categorize these evidence rules in accordance with the basic principles of evidence law and construct a system of Chinese evidence. So, as a flow chart, the structure of the provisions on procedural evidence as below. The one logical thread is relevancy. Two poles are burden of proof and standards of proof. Three statutory stages are presentation, cross-examination, and deliberation. The four value foundations are accuracy, fairness, harmony, and efficiency. Outline of provision include 9 chapters and 148 articles. So you can see the Article 2 is evidence relevancy. So we have 3 conclusions. Firstly, the construction of a modern system of evidence in China must at first remove the influences of objectivity evidence theory. Chinese evidence theories and systems are transforming from thinking truth from fact to thinking truth from evidence, from zero tolerance to wrongful convictions or wrongful acquittals to preferring wrongful acquittals over wrongful convictions, from correcting every wrong whenever discovered to correcting every wrongful conviction whenever discovered, and from lifelong accountability system to professional security system for judges performing statutory duties. Secondly, a trend of transformation from objectivity to relevancy is witnessed in Chinese evidence legislations, judicial practice, and academic research. The exposure of wrongful convictions in China, advanced adjudication by evidence, and the trial-centered criminal procedure reform laid the institutional foundations for the principle of relevancy. The last, to achieve the complete success of such a transition, a modern evidence system with relevance as a logical thread should be built up. More importantly, great efforts should be made to develop the education of evidence science, to cultivate a new generation of legal scholars, judges, prosecutors, and lawyers to master modern evidence science. Thanks. Thank you very much.
Thank you very much, Professor Baosheng. Now, open the debate and discussion. Please, if could ask for questions, and I have an idea with the participations. Well, your turn.
Ready? Okay. Thank you for your presentation, Professor. My question is the following. Has there been any effort or any attempt from the Chinese government to empirically determine how much a serious mistake is a false acquittal than a false conviction? Is there empirical information about it? 10 to 1, 20 to 1, 50 to 1?
You mean the wrongful conviction?
Yeah, how serious a mistake, comparing the two principal mistakes, a wrongful acquittal and a wrongful conviction, is there any empirical information from your government that kind of determines which is preferable and in what way committing a false acquittal is preferable from committing a false conviction?
Okay. Because in the past, Chinese judicial practice influenced by the, I mentioned, the objectivity theory. So, in fact, many people didn't recognize there are many wrongful convictions. In recent years, there are several big wrongful convictions exposed. So from the high-level justice and the judges just recognize they can make a mistake in the trial. But in many times when I give training in the courts and the procuratories or the police college, after I finish my lecture, I asked them, did you made some mistake case? They always say no, any. I'm correct 100%. So I think the judicial ideas is very important for the next judicial reform of China.
Arriba.
Muchas gracias, profesor, por la exposición.
Thank you. Thank you. Presentation. Just a question. When you talked about relevance, and you dealt with it in all your presentation, I was thinking not only of relevance, but also reliability when you talk of epistemic filters to admit or not the evidence. So what's your opinion about exclusion rules that are a hindrance or force us to take evidence out of the process that is relevant but not accepted? Many legislations in the world have rules that exclude some evidence that in principle is relevant to the process. Thank you.
Thank you for your question. I think for the in general, I argued in China, we should focus on the relevance rules because there are few articles stipulate relevance rules in China. Because the relevance rules are fundamental principle of evidence. So I think we should focus on the principle of relevance for next step Chinese judicial reform. That means remove the objectivity's influence. But you said reliability is very important, I think. But for evidence, I think the first attribute is relevance. If something or some word, some sentence has no relevance, they are not evidence. But after we decide something or testimony has relevance, we should decide whether or not they have the reliability. Reliability is very important, I think, especially it's an attribute of evidence credibility. Thank you.
Thank you, Professor Allen.
Yeah, thank you. Ron Allen from Northwestern University. I just wanted to follow up on Edgar's question because it highlights an important aspect of our deliberations over these 3 days, which is that some things that people may take to be universal are not. Much of evidence law is highly contingent. I lecture in China 2 or 3 times a year. The issue of what Edgar was referring to, the Blackstone ratio, or the ratio of wrongful convictions to wrongful acquittals, which everybody in the West just knows should be like 10 to 1 or 20 to 1 or 1,000,000 to 1 or whatever, is not the universal view in China. Remember that one of the ancient Chinese curses was, may you live in interesting times. And the reason that was a curse is that it was chaos that was to be avoided, not the occasional conviction of an innocent person. So when I ask these students, and I do every year in China, how they balance, the very question you ask, it's interesting. I mean, there are some people that embrace the Western approach, but there are many that say, well, we can't let these criminals go free, and that's a bigger threat to society than the opposite. But the point I want to make is not that there's a correct answer to that question, but the contingencies. How much evidence that can appear to be universal is in fact socially contingent.
Because I think in China we have a civil law tradition in the past, but in recent 40 years we received many methods from the common law evidence theory. So in the past, in China, there is no independent evidence law or evidence provisions separate from the criminal procedure law, civil procedure law, and administrative procedure law. But for the judges or prosecutors, investigators, when they decide how to master the evidence rules or evidence series to resolve the problems, they always feel the evidence knowledge is not a system, because they many articles in the different procedure laws. So it depends on the conventional civil law tradition, I think. So in recent years, especially the evidence scholars rethink maybe there are universal features or natures of evidence among the three procedure laws. So right now, I think this many Chinese evidence scholars has this common sense. We should integrated the different procedure laws, evidence codes into uniform the provisions on evidence. I think this is maybe easier for the judges and prosecutors master the principle of evidence.
Professor Zuckerman.
The reforms you have described are very impressive, progressive, and very intelligent. But the implementation in practice, the ability of individual judges to apply this new system and arrive at the truth depends on judicial independence, especially independence from political interference. Now, I've had an experience very similar to yours. You ask a number of judges, have you ever made a mistake? And they say, never. I discussed Chinese civil procedure, in my case, with a number of Chinese judges who were doing courses in Hong Kong. And I asked them, have you experienced political interference, ever experienced political interference? They all said, never.
You finish?
Yes, I can answer your question in my opinion. You know, I think for judge, Chinese judge or other countries judge, if they want to trial fact, he or she has to master some evidence principle. I think especially some technical rules, you know. But of course, I think the evidence rules in fact is experience of the trial. So, for example, in the past in China, there's a few evidence rules, but right now, I think in China may be the #1 in the world. We have 415 articles of rules, but is a lot of evidence articles than in the past. It may be the Chinese judges trial level haven't updated, not many, but I think that not means evidence law will not play important roles in China. So we are promoting this task, you know.
Before is this work.
Thank you, Professor Zhang, for your lecture. You have mentioned that there is a traditional judicial notion of zero tolerance to wrongful and convictions or acquittals. And I would like to know if you recognize in your system a revision contra reum to revise also wrongful acquittals. Thank you.
Okay, thank you. That I mentioned in the past, the Chinese judges, especially judges, they didn't recognize they made a mistake, include wrongful conviction and wrongful acquittal, because there are very serious accountability. If you made a mistake, you will receive a serious punishment. Like I mentioned, some judges could be sentenced by the mistakes. So I think the most important is change the judicial notions. If the evidence is just is a mirror of evidence, then judges cannot know, have no any personal knowledge for the past case, past fact, so they can only depend on the evidential reasoning. So that means they will have some probability of mistake. If so, I think we can regard the wrongful conviction or wrongful acquittal as normal. So I think this idea change is occurring in China. So in recent years, the judge and the scholars are always promoting the theory of evidence for the probability of the truth.
Here. Thank you.
Muchas gracias. Yo trabajo en un centro de estudios latinoamericanos.
Thank you. I work in a Latin American Studies Center in Santiago, in Chile, and a year ago we did a review on the regulation of admission criteria in criminal procedural studies, and we saw that never mind where from, there are, well, 15 different names, but in any case, yes, there is an admission of a complex interpretation, as is done by the Anglo-Saxon system. But however, we find that in the practice, and taking some specific countries as examples, there is a very rigid vision, understood simply as a relationship between fact and evidence. My question is whether in the Chinese system, has there been any empirical study carried out? I mean, about the practical understanding of a court session? And if not, what is the perception of what goes on day after day in all the sentences?
Okay, thank you. For the standard of criminal proof, you know, right now we have an article of evidence is stipulated in the criminal practice. The standard of the proof is beyond reasonable doubt. It's like the common law standard of evidence. But in fact, the many Chinese judges, especially the president of judge, president of court, they regard this beyond reasonable doubt as 100%, not the 95%. Not regard this beyond reasonable doubt as a probability. So, in fact, in many accountability examination, they always use the, just as I said, zero tolerance to the wrongful conviction or the wrongful acquittal. So if some judge admit they made a mistake or a wrongful conviction or wrongful acquittal, he or she will receive the punishment. So I think it's not, we cannot just reform in the legislation and but also we have to change the Chinese judicial notions. Thank you.
Thank you. Something else? Yeah. Thank you.
Muchas gracias.
Thank you. Well, congratulations for your presentation. I'm very interested. I'm from Colombia, a prosecutor. So from this evidence standpoint, I would like to know about the evidence that comes after judicial decisions. There is a double instance, so who would assess this evidence, or is it already too late once the decision has been made? So what happens with this late evidence? And then there would be acquittals or convictions that would be false. How does it work in China?
Thank you. Because the judges make decision in the court have to depend on the evidence, but the evidence itself, there are true or false, and there are big probative force or a small probative force, and like the professor Training said, there are many forces. So when the judge uses evidence to do the evidential reasoning, it is the possible to make mistake. But if they don't dependent on the evidence, he or she will not make a correct decision in the court. So I think this is a dilemma. So I think we should develop the education of evidence science to cultivate our students in because the students in law school is they are the future lawyers and judges. And if we let them master the correct evidence theory and some, I said, technique, method, some evidence rules. Maybe they can reduce the mistake in the court in decision making. But in China, I think it's like in other countries. This step we just in the way, on the way to remove the error, the wrong theory of evidence and the master the correct judicial notions.
But I think the question entails that if it's possible in China to reopen a finished case in virtue of new and conclusive evidence, new and unknown.
Oh.
And unknown until that moment and conclusive evidence. Okay. I think so. It's the no. I think so. It's
okay.
It's because in our countries there is an extraordinary mechanism to.
Okay. Because we have the traditional civil tradition, traditional civil tradition. So, as I mentioned, there is now the code of evidence right now. But I think the interpretations by SPC, as Supreme People's Court, can play the very important roles in the judicial practice. So the new provisions on procedural evidence may be published for the third level. Is the legislation is the fourth level. Interpretations is second level. The guideline is the third level, were published in for the 4,000 courts. They maybe can play this role.
Well, something else? Something else, the last question. Oh.
Emilio Alvarenga de Córdoba.
Emilio Alvarenga from Cordoba, Argentina. I have a question in two stages. One first about a minor subject, but there might be many people here in the audience that don't know about it. The system in China, is it predominantly written or oral? Do you write or do you speak more? And what about the digital evolution? That's my first part. And the second has to do with criminal or civil law. Well, no, sorry. The second is also minor, and I apologize, but I do think it's interesting for everyone. In China, about the burden of proof, the onus probandi, yeah, in the civil procedure, when there is a difficulty or it is impossible, well, how do you analyze, how do you distribute the evidence risk in order to act in a fair manner and to balance it out between the parties? Thank you.
Okay. For the digital evidence, I think in China is a little development because right now the Supreme People's Court just promote the AI and big database and said intelligence court information or website the courts. But for Chinese scholars, just varied the human rights may be influenced by this technical development, but not the select of digital evidence rules. For second, can you repeat the second question?
That's the final, yeah.
Yeah, the second is, in the civil process, how do you distribute the risk of evidence on the basis of the standard of the burden of proof and the impossibility that there is of counterbalancing the evidence? So does it go to somebody who is in better conditions? How do you go about it in China?
In civil procedure, I think in the past 40 years, we in judicial practice, we first developed the civil provisions on civil procedure law by SPC before the criminal provision, before the provisions on evidence in criminal procedure law. So many Chinese scholars think the most important is develop the criminal procedure evidence rules, but in fact the provisions on criminal procedure is less or less than the civil procedure law evidence rules. So maybe the evidence rules can play more important roles in criminal procedure law. But in the civil procedure, it's because the standards of proof is law, and the judge can play the discretion. So this may be the future trade.
Thank you.